Hey everybody, welcome back to the weekly podcast. My name is Patrick Tan, the General Counsel for ChatArgos, the blockchain analytics firm made famous for discovering the under-collateralization of BUSD by 1.4 billion US dollars. With me, as usual, every week is our CEO and Chief Data Scientist, Jonathan Reiter. Say hi, everybody.
Good afternoon.
And we're happy to have this opportunity to speak to you guys. Thank you for taking the time out of your busy schedules to tune in. Thank you for all the great feedback you've had. I see you guys have really enjoyed the that bit we did with the Crypto Critics Corner. That stuff is still going on. I mean, there's still you guys are still listening in and watching that stuff. We really appreciate it, and thank you for tuning into the show as well. So on this week's episode, what we have for you, a bit more on the regulatory side, maybe a bit more than usual. We're going to cover all the major events over the past week, of course. One of the things that we want to talk about definitely is FDUSD,
which is the simplest on-chain analytics you can imagine. So there you go.
So FDUSD, for those of you who may not know, is First Digital US dollar, right?
Yep.
It's not. It doesn't stand
I
for.
think that's what it stands for.
I mean, it could stand for fake digital US dollars. We don't know. So
they're truly digital. I'll give you that.
well, it's fake, but it's fake, digital US dollars. So we're going to talk about that, what's been going on over there. We've done some analytics, not too much. It wasn't very difficult to do. We'll talk a little bit about the chief accountant, is that correct?
Yep.
Chief accountant for the US SEC, and some of the comments he made on something that we talked about. I don't think it was on this show, but it was on Cass PNC's and Bennett Tomlin's show.
Oh, we've talked about a fair amount.
We talked about it a couple of times, about this whole thing about assurance.
Attestations.
The whole theater of the whole thing. I'll talk a little bit about some of his comments regarding crypto assurance work. And then finally, we'll talk a little bit about this bill that's passing through the House. What's it called again?
Yeah, so there's a what's sort of colloquially known as a market structure bill and a stablecoin bill that are both purporting to deal with some of these issues. These are not laws yet. These are things being debated and shaped.
And for those of you who are not familiar with the U.S. Legislative process, it's a bit like if you've eaten something that's really indigestible, it'll take a long time to pass through.
Well,
there you go.
Okay. The phase that we're at is the phase that can go in a loop forever. This is not the procedural going towards being passed. This is the refinement discussion. The process is quite complicated, but we're at before the actual official procedure for something to become a law starts. This is just the indefinite debate phase.
Yeah. So let's talk about FDUSD first, because
okay. So FDUSD is a fascinating and simple product.
Yes.
So we talked about a little bit about this, I think, last week. So this is a stablecoin that's been launched by a Hong Kong trust company called First Digital that's been doing digital asset custody type stuff for a while.
And let's just pause for a while. So First Digital, we know from the True Dollar days, right?
Yeah, no, they've been doing this for a long time. Yeah,
correct.
They've been involved in some
So
stablecoin.
First Digital used to hold, and this is just for some reference, First Digital used to hold, allegedly, dollars for the True Dollar people.
Hundreds of millions of dollars. So it was a large-scale operation for years.
So they would hold True Dollar. So whether or not there's any link with what's going on now, we don't know. But, well, we kind of know. But, and so?
So they announced that they were launching this new stablecoin.
Yep.
Fine. And presumably wherever they bank and hold their reserves, they have some places to hold dollars because, they had dollars for a long time.
Yep.
Fine. And they're associated with a Hong Kong trust company called Landmark. Landmark, I think. It's been around for a long time. So whatever, fine. So they launched this product, and immediately Binance announced that they would be doing fee-free trading and all the usual, coordinated announcements involving the Binance and Tron folks. Somehow all the same people, the Tron folks who also we now know own the True Dollar and who used First Digital for at least some of their custody. Fine. So this thing started up, and almost immediately it's got some use, not massive market cap, but millions of dollars, and well over 99% of the tokens are on Binance. So, okay, when we said the simplest possible on-chain analytics, I'm just going to go here to, I think it's just Etherscan. So on Binance Smart Chain, there are only 9 addresses that hold this thing, and on Ethereum there are 9 addresses that hold this thing. 3 of them are Binance addresses in each case. Just 2 of them are just tagged per public. There's no analytics needed on this one. This is just a way of getting dollars into Binance. Whatever. It is amusing because Binance is, of course, the largest, but not the only exchange. So if this thing doesn't start to get used a little bit somewhere else, crack the double digits in holders, and even the triple digits in holders, then it's very obviously just a on-ramp, off-ramp mechanism for Binance, which I guess is okay in the abstract. For me, the problem is that, why did Binance lose its banking in the first place? And this is so glaringly, obviously, just an on-ramp. I mean, if they're holding 99.9% of the tokens and no one else uses them, come on. And then whoever was, cut them off before will try to cut them off now. That doesn't seem like a huge leap. It's a dangerous game.
It's, I mean, just to help you guys to understand this a little bit. Essentially, the reason why Binance is where they are right now is because they lost access to all of their banking. Now we have the FDUSD.
They've not exactly announced that, but they've sort of announced that, and for some parts of the business. But yeah, okay.
In a nutshell, just to understand it simply, correct. I mean, they've not completely lost all of the banking, but for all intents and purposes, it is very difficult to get real currency into this exchange.
Yeah.
Now, you do this deal where you have the First Digital, and then First Digital has bank accounts presumably somewhere, could be in Hong Kong, could be anywhere, and then they are somehow shoveling dollars into First Digital using that banking facilities to swap it to FDUSD. FDUSD gets onto Binance, that facilitates trading, and that sort of helps the flow of dollars in. Now, as we've seen, that if people if regulators are determined enough, they can cut off those rails, because what would happen is that,
First Digital has SWIFT codes that are still domiciled in Hong Kong.
Exactly.
Like, it's pretty trivial to go after that.
Yeah, and cut them off. So this is a dangerous game, as you rightly mentioned.
I mean, it is particularly amusing if the stablecoin operator is itself a trust company, because it feels pretty unlikely they're using another custody provider, and so exactly which. I mean, you go in and you can look up SWIFT codes online. You don't even need special finance industry access to check this one. Unlike some stuff that we may or may not go through. You can just go to the SWIFT code, whatever, look at, and you find the, I think it's FDFDHK, something like that. That's easy to turn off. And to me, it sounds like they don't have a lot of better choices, because, again, this is a theory, but this theory is consistent with the data that's out there. It looks very much like this is a fresh on-ramp attempt that is transparently just a fresh on-ramp attempt and should be super easy to cut off if somebody wants to. So this doesn't feel like what you do when you have a lot of better choices. This feels like what you do when you've run out of other choices.
Yeah, otherwise you wouldn't have a handful of addresses and 99.9% of the FDUSD only being on Binance. It just makes no sense.
And some of the people in the orbit of this stuff have historically set up, BVI-based stablecoin service providers, and then they get a trust company, and that stuff, whatever kind of it means at a higher level, is harder to sift through. It's more complicated. There's more indirection. They may have an easier time opening at a number of banks and be able to have more complex infrastructure. Here you have a trust company that's overtly attached to a stablecoin. Yeah. So even if they go to a different bank to try to get a trust whatever bank account, they're not going to have any. And then if on-chain all the holdings are from one exchange that bank previously cut off, you don't need to be an expert data scientist to see through this one.
Yeah. So talking about that, before we jump, so there's a bit of bonus content, because I didn't say that we were going to talk about this, but there is a theory that's been floating around and that we've looked at regarding USDT's market cap. Tether's market cap has been increasing, and USDC's market cap has been decreasing, as has all other stablecoins. Again, that doesn't necessarily mean anything, but because it's what you would expect. You would expect definitely for USDC and the rest to start decreasing, because these are, those that have had the kibosh put on them as stablecoins, we're going to decrease anyway.
Well, they're one-way only market cap.
Correct.
Yeah.
So, but USDC would remain the only off-ramp for stables. The only proper off-ramp for stablecoins.
Well, it's the easiest, right?
It's easy,
if you're KYC'd with Coinbase, you can do that. So it's a large number of people who can pull that.
So and that's why it's understandable that people might swap, say, I don't know, Tether for USDC off-ramp. So some people have been suggesting, and I'm not saying that it's true, not true, it's just what we've seen, there have been some people who have been suggesting that USDT's market cap has been increasing because it's minting unbacked Tether, and why is that not possible?
Well, I mean, it's possible, but there's no there is no evidence to suggest that anything different is happening. So what you'll see probably is people redeeming Tether is notoriously difficult.
Yes.
So most end users, I'm going to assert the vast majority by number of end users, of Tether users, have no ability to redeem because the minimum $100,000 transaction is just way out of the realm of possibility for most users. Fine. People would then sell for another stablecoin, redeem that one, whatever, do something with that one. So in that case, the market cap of Tether stays flat, and the other stablecoins all drop in market cap. That's totally fine. That's well understood. Even if you then took those dollars and went back to Tether, right, you would see Tether's market cap go up a bit, and USDC or whatever that was redeemed go down, and that's all totally back, totally reasonable, fine. Is it possible that unbacked Tethers are minted and sold for USDC, which is redeemed? Sure, but people have always alleged that was the case.
Correct.
We have no solid understanding one way or another. Nothing new has happened.
Yep.
The divergence is a bit more dramatic as more money's getting sucked out of the system. So in 2020, 2021, all of these things were going up, and it is plausible that money was coming in from all kinds of directions so that everything was going up, even if probably at that time there was more Tether being sold for USDC to be redeemed. Anyway, there's nothing dodgy going on there, right? We've not seen any actual evidence of somebody printing completely unbacked Tether recently in a new way that has been asserted before. You know, this over-collateralized lending and investment in Celsius and all this garbage for years, but none of this is new. And I don't know why people would get excited about that all of a sudden.
I also think that, and I mean, this is obviously, first of all, we don't really have any evidence of anything new that we don't already know. And I also think that, you know, if you are a fentanyl-based chemical precursor supplier, if you're going to be taking Tethers, and if they're continuing to be able to take Tethers...
I mean, I think the assumption has always been that, because there's now more and more... legal cases, whatever, people getting arrested for stablecoins and crypto cross-border, whatever, that either those people or people are related to those people are actually proper customers.
Yeah.
Right? It's okay. So we can go back again to the Genesis Block example. They were definitely dealing with some shady individuals, and those guys, Genesis Block or Alameda, who it turned out owned Genesis Block, they were on board with Tether to mint and redeem. Yeah. So there was real money flowing in and out for the type of people you just described, or indirectly through their OTC providers. But the end users don't have any access to that. That's not a new feature of the system.
It's the same thing. Yeah. So just a bit of commentary about that. Okay, let's talk about the bill.
Just to be clear, it's possible there's all kinds of unbacked crap going on.
Oh, yeah.
But there's no new evidence here. People are just asserting the same old unfounded theories.
Just the fact that we're seeing this huge divergence where we're seeing Tether's market cap go up and then the others go down, it's not something that Tether's market cap is independent of the other one. It doesn't mean that because the market caps for the others going down is what you'd expect to see.
And that's completely consistent with real dollars moving from here to here.
Yeah. So
I mean, nobody has ever asserted that Tether won't accept real dollars.
Yeah.
The question is whether they'll accept other stuff. If you go to them and say, "Here's $1 million," they will definitely take it from you and give you the tokens. Right then. Anyway.
So let's talk a bit about the bill. Let's just point out a couple of the interesting bits about that bill that's passing through the House right now.
Yeah. So there's two U.S. bills that are currently being not passing, but whatever, debated, discussed.
Correct. It'll take a long time before this is like that long.
It could, yeah. So
that really challenging Mexican meal that you had. That it's not even really.
Okay. Yeah. Anyway, so there's one that seeks to deal with stablecoins, definitions, and regulatory framework, whatever for stablecoins, and then one about sort of more generic. It's referred to by people as a market structure bill. It's trying to delineate what is the CFTC's responsibility, the SEC's responsibility, what's whose responsibility, issuers, and whatever the rest of it. It is this is not a judgment about the quality of the policy decisions that are made. It is a coherent attempt to try to lay out what the issues are and say things about them.
Yeah.
Whether or not the things it's saying you agree with are separate, I think everybody who reads it will say, the basic issues here, what does decentralized mean? Yep. If there is no issuer, who is supposed to ask for the license, right? That kind of stuff. So they're at least laying out some of the basic questions and starting to deal with answers. I think the enumeration of questions, I'm not sure many people will disagree with. I'm sure people will disagree with the policy approach, the answers, whatever taken. In the case of stablecoins, it's a little bit different in that the general question most people have is whether or not unrestricted cross-border capital flows, linked to fiat currency, should be allowed or not. And the general tenor of the bill is to allow a wide range of regulatory structures to look at this, but for everything to fit under the Fed, which already supervises the dollar payment system. So that is definitely not going to allow a completely permissionless on whatever AML KYC free type of arrangement. So, philosophically, I think people will have maybe bigger underlying questions with the way that one's designed, whereas the market structure bill, different bits of the market structure people will care about. I think it's so okay. Set the sort of stage there. Now, on the market structure bill, the part that I found most amusing, so they go through and try to define what is a decentralized, whatever, what decentralized means. And the point here is, this is well acknowledged for a long time, if there's no real issuer for a token, whether or not it's a security, whatever, token, who is supposed to file the paperwork? So in certain cases, if something qualifies as decentralized, I'll come back to that in a second, then essentially anybody can go ahead and ask for a finding that this is a decentralized whatever type token. That's in lieu of a formal issuer securities registration process, and then it would fall under a CFTC regulatory regime for effectively commodity-like stuff. If it's not decentralized, it's basically treated as a security, and it's the SEC's responsibility overall.
Yep.
And generically, the SEC gets to not exactly reject, but object to these claimed filing requests for acknowledgement as decentralized. The conditions they put for something to be properly decentralized are not crazy, and they're pretty difficult for most of these systems to achieve, right? So you can't have more than, I think it's 20% of the token holdings under any one entity or indirect control by that entity. Can't have modified the code for 3 months, 6 months, whatever. Holders, and there can't be people updating the system, whatever.
And 12 months.
Is it 12 months? Okay, I can
so
find the exact.
there's like basically, if for the preceding 12 months, if you've had situations where there was some form of centralization.
Oh, there you go. Yeah. So if in 12 months there was any centralization, you don't count. Even deploying software updates and whatnot that are centralized doesn't work. If anybody in aggregate held 20% or more of the total amount of units, restrictions on whatever, 3-month period, anybody implemented or contributed intellectual property that materially alters the functionality or operation. Okay, it goes on a bit from here. Any issuances that are end user distribution, so whether you're selling to end users or so, you cannot sell tokens in a project that's not finished yet, that isn't well finished and polished, and have it qualify as decentralized.
Yep.
End of conversation. So you cannot use this to fundraise for new blockchains.
Yep.
End of conversation. I don't think people appreciate that.
I want to make it clear that this is just up for discussion. This is a draft.
And this draft feels like, if I had to guess, it was financed by a bunch of people that already launched a bunch of blockchains they think will qualify.
Yeah,
right?
You would think that this favors the incumbents a lot.
Yeah. It is very amusing to hear someone describe this as sort of fostering innovation, when in fact what it's doing is raising the gates behind the half dozen or so. So ETH and Bitcoin would almost certainly qualify.
They'd be fine.
I mean, you can discuss whether consensus and affiliates actually control more than 20%. I don't know. We can come back to a discussion of how the SEC is supposed to figure this out. But some new chain that has a foundation with 80% of the tokens just prima facie fail.
Yeah.
Right? The SEC has 30 days to object to such claims under this framework. I think it's challenging, the question of whether one entity controls more than 20% of ETH or Solana. I have opinions, you have opinions, but I don't know. The government, from a standing start, isn't going to be able to come up with a clear opinion in 30 days on that one. Now, for Arbitrum, where the foundation had all the tokens, it's going to take them about a day and a half, assuming there's an explorer. It gives you weird incentives.
And this is obviously this is quite far away from becoming law. But this would be challenging on many levels, and one of the basic levels is that a lot of these projects, they always give you the promise of decentralization. It's never upfront.
Oh, well, this makes it clear that does not qualify.
Exactly.
If you promise future decentralization, you're running a security.
Simple agreement for future decentralization.
Well,
accept.
No, I don't think people appreciate the extent to which this is not going to allow new stuff to get created, and probably. I mean, it certainly smells like the legislation itself was financed by people associated with existing chains, and many of those people have provided financing to bits of the media, whatever, in the space, and probably would be interested in that kind of stuff continuing, right? Yeah. If you think of what? Ethereum, Tron, Binance Smart Chain, Solana, Avalanche. These are the people who have some chance of being able to qualify for this exemption. Nobody else does. I will say, on a sort of more basic moral level, the idea that the government in 1 month has to come up with a detailed rebuttal to what are, in some cases, complicated technical questions, I find offensive as a person who has to participate in a legal system. That's nuts, right? They should need to present evidence that their thing is decentralized, and the government should have to say something about that in that direction. Well, I mean, it's just the exercise I went through with the BNB beacon chain 6-7 months ago shows you how hard it is for, and I'm not trying to sound arrogant here, but for an expert to even figure out what the hell's going on. It is totally unreasonable.
And that's fair. Like, technical subject matter, I mean, we do this day in, day out. And you expect somebody who's in the government who doesn't just do this, they do a ton of other stuff, and then to expect them to come out with an answer in 30 days, it's...
and that's separate from the idea that no one wants the SEC to hire a bunch of technologists and then opine on whether or not certain projects are okay or not, right? That's just not how this is supposed to work.
Okay, so, but based on the iteration of this draft bill as it is, would it be fair to say that, let's say, for instance, I wanted to set up a new blockchain and I wanted to issue tokens to fundraise for that new blockchain, but I registered those tokens as securities with the SEC and then put in all the requisite investor protections? That's fine, right?
That's always been fine.
Exactly.
No one's ever questioned whether or not that was okay.
Yeah.
So the only thing that's different here is if you somehow manage to have an existing functioning product with diffuse ownership out in the world, then you're exempt from
from that perspective, you can't actually just go and say that this is innovation killing, because all you're saying is it's investor protecting. You know what I mean? Like, you're going to raise something that is for a project that...
Oh, no. I disagree with you. Because this puts a handful of existing established projects in a privileged place.
Correct. I get that. They got away with it. So what I'm saying is that, you know, to some extent, they got away with it. It's kind of too late for that. In you know, you could go back. Where are we gonna find, you know, those guys?
Well, it's not too late for that.
So, okay, so let's say now, for instance, to take the argument to its logical extreme, if we say that all these guys have to have registered their initial, like Ethereum, for instance, like when the foundation was there, their initial ICO, they should have registered as a security offering. They didn't. It's kind of, you know, in the past. You know what I mean? Like.
Well, okay, no. So let's step back. I think that's a misunderstanding of how the system is supposed to work. So what you're saying is that it's not going to be mechanically possible in cases where the price went down as opposed to up for the investors to get their money back.
No. What I'm saying is that
I agree with
the harm of that, failure to protect investors, that ship has already sailed. And to get them to register...
But that's always sailed. Okay.
You know what I'm saying?
Yes, so fine. But that ship... The way regulation works in most of the West, that ship has already sailed every time.
No, correct. So there are laws that prevent certain new laws from having a retrospective application.
No, sorry, I'm saying something different. So generically, the way the system works is by the time they catch the guy and they make them buy all the tokens back, they don't have enough money, everybody goes bankrupt.
Yeah.
The regulatory system works by having the fear in people of that happening.
Yeah, I get that.
So in this case, what you're saying is the people who founded whatever, Ethereum, Solana, Coinbase, somebody that's in a questionable security situation, people who are designated control people of those entities would be bankrupted by the proceedings you're talking about. That doesn't get investors their money back. It doesn't protect anybody.
No.
The way that indirectly provides protection, the way the American system has worked since the 30s, is people will look at management of those companies going to prison and being bankrupted, losing all their money, and the fear of that happening prevents you from the fraud in the first place.
So
I'm not saying that's the right system. I'm saying that empirically is the system.
So no, we're on the same page here. That's what I'm saying. I'm saying that actually the bill as it stands isn't necessarily anti-innovation, and it does because you can still go after these guys. If you can still go after these guys if you remove that artificial.
Okay, but
some of those artificial barriers.
Certainly this stuff was illegal at the time, so this is not going to work retroactively.
Yeah.
My concern would be that you then put whatever, a couple dozen or so projects in privileged position with respect to new stuff, and launching a new thing that has to deal with all the securities mean, the whole point is that the burden of being compliant with regulations should be the same for everybody.
Yes.
Otherwise, it really is unfair. I mean, this is why the U.S. in particular has a huge aversion to government-owned businesses, because they don't want to compete with private businesses that have different sort of sets of rules and funding requirements and the rest of it. That's why the U.S. doesn't have a state-owned bank, because there's a resistance, 19th century, whatever, to that kind of stuff happening. So it is unfair, or at least it's an uneven playing field in that sense. I don't know. It does look like an attempt to get these things regularized for a small set, and actually makes it clear that a lot of what people want going forward would be outright blocked.
Yeah.
Right. So you cannot launch a new blockchain tokens the foundation owns and qualify for any
sell those
exemptions
tokens.
at all. Yeah.
And sell those tokens. Yeah.
Yeah.
Which I don't know. We'll see. Just to make it clear, this may or may not ever become law.
I suspect this is pretty far away from actually turning into a law, at least in part because there's no way the agencies that are tasked with enforcing these rules, you saw this with the Fed and the Stablecoin one, in addition to the SEC with the market structure one, will be asked by Congress what they think, and they're going to say, either I can't enforce this at all, or you're going to have to give me an awful lot more money to enforce this. And that doesn't seem like something that's going to be very popular.
And so in the meantime, that doesn't mean it's off to the races. It just means that the SEC will have to go about this on a piecemeal basis, which is already doing.
It is hard to see both the SEC, the other whatever finance regulators, and much of the traditional financial system being okay with a new regime in which certain people get to assert they're exempt from the rules, and the government has a 30-day stopwatch running to prove that they shouldn't be exempt, or they're just free of all the rules. Why would the equity trading, why would all the members, why would people be okay with that? Right? Large brokers are not going to like that. Interactive brokers, whatever. These kind of people are, why are you exempt from these rules? The issuers, whatever. There must be a Securities Issuers Association. I know there's trading associations. I don't know.
Well, finally, let's talk about what the chief accountant at the SEC was saying.
This is fantastic. So we've talked about weird-looking attestations and audits for a long time. Yeah, so this guy's come out. Would you call it a warning?
Sounds like one.
As a threat, maybe?
Yeah. I mean, even though it says quite clearly on the blog that these are his personal views, he actually just states law.
Well, I mean, they're his personal views published on SEC.gov, so exactly how personal.
And he refers to many laws and many regulations.
Stuff going back to the 80s. And these are not even in question. I mean, generically, if you're a auditor with the auditor accounting license, whatever, that type of stuff, code of conduct, whatever type things, you're not supposed to let people misrepresent what you've done. This is exactly what Paxos got in trouble for with the Binance dollar.
Correct. Right? So TLDR, if you haven't read the thing and if you don't want to read the thing, what the chief accountant at the SEC is basically saying is that if you're an audit firm and you have accounting firm, whatever, and you have certain licenses and you have certain professional standards that you have to hold yourself up to, and you produce something that's not a proper audit. So like none of these guys have had a proper full audit. Top to tail, maybe outside of Coinbase, but everybody else, nobody's done like a full audit, balance sheet, cash flow statements, every single piece of forensic accounting that needs to be done in an audit, in a real audit. But you do something that kind of looks like
these agreed procedures, investigation type
kind of thing, qualified opinion / attestation / we looked at the bank account and that's all we're saying. If you do that, and the guy who's your client takes this and proclaims to the world that we've had an audit by such and such firm, they have of such and such a standard, and then starts to use that as an enticement to get. You may be responsible for that. Well, you're gonna be responsible.
I mean, I would say that in fact many people don't realize auditing firms do audits. They also do these agreed procedures type things, more mild. That stuff exists a lot of the time for non-financial use cases, right? So if I'm looking at buying a factory or acquiring some chemical process, you can hire these guys to go in as part of a mergers and acquisitions type situation and do a quicker confirmation that stuff is as you said it was. Auditing of public companies has a whole long manual and there's procedures to follow. Determining whether or not a factory is producing chemicals in the yield they claimed is not. There's no manual, right? Or at least you pick whatever particular use case you want to look at. So people will go in and follow certain processes and check that stuff was done a certain way. Warehouse efficiency, transportation network, package delivery, whatever. That stuff being repurposed, that's not for presentation to retail.
Yes.
That's for business,
Correct.
due diligence type stuff. Presenting things from that space in a financial context to retail, to individual investors, is kind of somewhat new and clearly open to abuse and being misleading, and a lot of these things are disastrously misleading.
So just to give you an example, let's say now we were to issue a stablecoin that's called the ChatArgos dollar.
There you go.
The CAD.
That's the Canadian dollar.
Exactly. Coincidence. Anyway, so let's say we were to issue the CAD and we told some audit firm, hey, just look at these two wallet addresses, look at the bank account, and then that's all I want you to look at. These two wallet addresses and the bank account. Now behind the scenes, what John might not know is that I'm quietly minting a whole bunch of unbacked CAD somewhere else out of a different smart contract, different wallet. But he doesn't know, nor does the accounting firm know that we're doing that, because we gave them a very limited ambit. In the meantime, him not knowing that I'm happily minting CADs out the back door to go gamble on some exchange and pump prices
in Canada. There are casinos in Canada, Canadian
exactly.
dollar.
That's where we're going to roll the dice.
Montreal.
And then so we'll take and then he'll take this attestation, slap it on the website, tweet about it, put it all out there on social media. Every single CAD is backed 1:1 until somebody like John goes and checks it out. It's like, hey, what's going on back in
where
the
those tokens from? Yeah.
where all you look at the market cap of CAD and then you see, but wait, that can't be right, you know. So and that is the major danger that a lot of these, let's face it, we don't have big four accounting firms doing anything even remotely close to attestations for any of these stablecoins or any of these things. It's so like, I wouldn't even call them tier 2, tier 3. They're just accounting.
Now that you say that, something just occurs to me, of course. So there were comments out of, I think it was Hogner, Tether, years ago, saying that they were trying to get a proper larger auditor, but that the negotiations were extremely protracted. I now realize, between what this guy wrote and what you're saying, it is possible that those negotiations were not really so much around the procedures themselves, but around the procedures for explaining what this thing was, and a large audit firm trying to be very careful that it wasn't misrepresented as something that it wasn't.
Yeah.
It had not occurred to me, and I've not heard anyone even speculate this one before, that they came to them with a fairly straightforward procedure, and the response was, we can follow this procedure, there's a bunch of wallets, and that's okay. That would explain, like Ernst & Young, whatever, they can figure out how to check half of those blockchain addresses and bank accounts. None of this is challenging for large audit firms. But the process of agreeing how you're going to present it and word it, those negotiations may have been protracted, painful, and ended poorly. That actually, to me, makes more sense than the previous explanations that have been given. You look at the way the BDO stuff came out in the end, it was weird, and the phrasing was unconventional for financial
a lot of this
stuff,
when it came out, made no sense. You know what I mean? So it makes more sense to me that they went to the accounting firms. Accounting firms would be like, well, they would have run that through compliance, and some other GC like me would have gone, no, you're not putting that out.
If they'll pay you enough, it's okay, but you have to make sure that it's represented in a reasonable way.
I mean, there isn't enough of pay me enough that would...
No, but I mean,
would jeopardize
they can pay you more for heightened risk, and it's a more complicated process to negotiate the thing.
But then taking that and saying that that's a seal of approval...
Exactly.
No.
I can see how probably some negotiations broke down on that basis. I mean, I have never been an auditor. You've been a lawyer that has similar types of rules to follow.
We work with auditors all the time.
But I mean, the Bar Association...
of course.
Not ethics code, but whatever, that kind of stuff.
The hippopotamus clause?
No. Anyway, but I'm aware there's stuff like that for auditors, and I have no idea how strenuous the compliance procedures, but I can totally believe a lot of this has been falling down on what this guy is talking about.
So, and on that basis, right, so now...
they're going to come after these guys.
So if this is the warning, this is going to actually make things even worse, because it means that even those accounting firms, small outfit, maybe 2-3 guys, who may have been considering, well, look, we kind of need the money, we need to kind of do this stuff, they might not even take it.
One of the sections is entitled Potential Liability Pursuant to Rule 102E of the Commission's Rules of Practice. That, to me, seems like a pretty direct threat to these folks. So if you've been doing stuff and allowing misrepresentations because those are the only customers, high-paying customers, whatever you can get, if they come after these guys, and of course, remember, the most notorious, whatever, the most common firm to pop up for a long time was Armanino.
Yeah.
They did some FTX stuff and some stablecoin stuff, and then some people from there left and set up the network firm, which did the True Dollar and a number of other things for a while that were a bit suspect. If they pursue those guys, we're going to find out the terms under which they left Armanino, and it will be very interesting. It will be very interesting to see what happened there. Given that they're now severed, you'd expect whoever's left at Armanino to try to put as much liability on the partners who left and reconstituted themselves doing the same business afterwards. And, auditors are probably pretty good at keeping records. So I bet there's some emails about those discussions and what were you doing? You need to resign now. That could be fascinating to watch. We may learn a lot about what's been going on. I don't have any idea what the confidentiality requirements are for audit engagement negotiations that didn't lead to a contract.
Oh, that's a good question. I don't even think that they're privileged communications.
I have no idea.
Well, you're not speaking to an attorney, so I don't think there's any kind of unless you sign a specific NDA before the guy walks into your office. I don't necessarily.
No, I would expect they're not. Yeah.
I would. These are not. I can tell you that at least based on statutory legislation, regulations anywhere, that may not necessarily constitute.
So if they start to go after these guys and ask some large audit firms, did you ever hear from anybody associated with certain stablecoin issuers? And they, sure, you're going to have to get a court order. Here you go. We may get to see some fascinating conversations. I would perhaps not be shocked if the SEC already had some awareness that this information was available and that this guy, the SEC's chief accountant, doesn't issue public threats very often. I'm not aware of this kind of thing ever.
I've never seen. Well, you know what would be even more interesting though is, if on the basis of the reliance on these attestations, you can show that a class of investors or people have suffered loss.
Yeah, for sure. Yeah.
This is a beautiful class action lawsuit.
Arthur Andersen was sued by all kinds of investors.
Exactly.
Yeah.
Sued into oblivion.
So just to be clear, Arthur Andersen was Enron's accounting firm. They were associated with a number of accounting scandals about 20 years ago. Arthur Andersen ended up being convicted of or pleading guilty to felonies. The firm was shut down.
Yeah.
All kinds of stuff, investor lawsuits, whatever. People were dealing with that one for many years. There is precedent for accounting audit firms that are far enough outside of what's okay. In the case of Arthur Andersen, it was generally considered a mistake to kill the whole firm because that had all kinds of implications.
Yeah,
it used to be the big five accounting firms.
Correct.
The big four.
That is true, though.
But if these are smaller firms going off piece doing stuff, there certainly are prosecutions against much smaller accounting firms. Who were the two dudes from Madoff at the whatever that two-man accounting firm was? Those guys ended up with serious problems. There's a big gap between Arthur Andersen and the two dudes who were doing Madoff's accounting in a strip center. It's believable that there's going to be some difficulties and that the large firms have probably protected themselves better.
They don't have their fingerprints on any of this. So
I told many people I didn't understand why these large accounting firms weren't okay with taking some of these engagements and writing stuff properly. It had not occurred to me that maybe they said this is the fee and this is what the phrasing has to be, and that was rejected. The negotiations broke down there.
Yeah.
That actually makes more sense to me than anything I've thought previously. Anyway.
Well, there you go. And on that note, in this week's extended episode, we hope you enjoyed that. We hope you add it to your wherever you're tuning in to us from. As usual, if you have any questions, hit us up in the comment section. We love it when you do that. Smash that like and subscribe button, and be sure to share those videos if you like them. Otherwise, we'll see you again next week. Thank you for tuning in. Bye-bye.
See you.